Hi everyone, thanks so much for joining us today for the final presentation in our FS Spring series. If you've made it to all of these sessions or you're just dropping in for this one, we really appreciated you tuning in. Today, we're going to give you an introduction to authorised push payment fraud, and then we'll move on to recent developments in the case law around the duty of care a bank has where push payment fraud takes place. As always, just a little bit of housekeeping before we get into the swing of things. I'd be grateful if you could please keep your cameras and microphones off during the presentation. We may not have time for questions, but our contact details are on the final slide. Please do get in touch with us if there's anything you'd like to discuss. And finally, we are recording today's session and it will be distributed following the presentation. So just as a very, very brief agenda, I'm going to give you an overview of what authorised push payment fraud is and how consumers have traditionally had recourse where they've fallen victim to an APP scam. Sylvia is then going to take you through how the courts have traditionally dealt with APP fraud and how recent case law may be paving the way for a new approach. So what is authorised push payment fraud? So authorised push payment fraud, and also known as APP fraud, refers to a situation where a customer authorises a payment and either the customer intended to transfer the funds to another person but was deceived into transferring funds to a completely different person, or the customer transferred funds for what they believed were legitimate purposes, but were in fact fraudulent. It's called authorised as the individual gives their consent to make the transfer, albeit this may be under false pretenses, and it is a push payment as it's the individual who sends the payment to the receiving party, rather than the receiving party collecting the payment, such as by way of direct debit. One thing to point out here is that given APP fraud's prevalence within the payment sector and the discussion on the scope of Quincecare to follow, in this presentation we'll mostly be concentrating on how APP fraud affects banks, but it is much broader than that. So there are kind of three common types of APP fraud. And the first one I've got here is impersonation fraud. So this is where a criminal might impersonate the fraud team at your bank to convince you that your account is unsafe and you need to transfer funds to a safe account, but actually this is controlled by the criminals. You also have investment scams. So this might happen where a fraudster convinces an individual to transfer funds to secure an investment which might not actually exist. And third one is romance scams. So a criminal may lure their victim into believing they're in a relationship before asking the victim to send money. So there's been a significant rise in the prevalence of APP fraud during the pandemic. The pandemic forced a dramatic shift to a more virtual and online environment, practically overnight. Criminals have then used this opportunity to target victims online, given the massive upheaval and stress that this has caused for many people. I know I certainly received one of the scam texts asking me to reschedule a parcel which Hermes were unable to deliver, though I knew that was fake as soon as I read it, as Hermes customer service has never been that good. UK Finance reported in their Happier Fraud update published last month that in the first half of 2021, £355 million was lost to APP scams, and this actually overtook card fraud losses. If losses due to APP fraud continue on the same trend throughout the second half of 2021, and the figures on this will be published later this year, the total figure for the year could be much higher and likely to exceed the total of £479 million lost to APP scams in 2020. And even these reported figures don't show the full picture. The totals here, the totals given here take account of reported APP fraud only, and so there will likely be more money lost to fraud that we don't know about. So I've taken you through what authorised push payment fraud is in a more academic sense, and now I want to give you a slightly more practical example. So on the next slide here, we have a picture, and for those of you who are Netflix subscribers, you'll recognise the person on the slide as the Tinder Swindler. The gentleman in the picture is Shimon Hyatt, a convicted fraudster who went by a number of names but carried out the Tinder con under the name of Simon Leviev, claiming to be the son of wealthy diamond magnate Lev Leviev. The fraud would begin with him matching with another person on the dating app and taking them on a luxurious first date, sometimes involving a private plane, as shown in the photo. Once he'd gained the trust of the individual concerned, he then claimed he was in danger. His enemies were after him, and he had no access to his credit cards as they could be traced, and asked that his Tinder matches send money to him. He would then repeat the cycle with other women to fund his lavish lifestyle. And worldwide, he's accused of owing $10 million to the people he met through the dating app. The Tinder Swindler, whilst he's a very famous example thanks to Netflix, is not the only instance of romance scams or fraud. There was recently a British Tinder Swindler who was sentenced to 4 years in jail after scamming one woman out of £157,000 over a 2-month period. So what protections are available to consumers where they fall victim to an APP scam? Sylvia will go on to discuss the Quincecare Duty and the potential extension of its applicability, but it was historically considered that a bank didn't owe a duty of care specifically to individual consumers where APP fraud occurred. It's fair to say it's been a bit of a mixed approach to APP victims in the UK to date. Historically, it's been up to the payment service provider, usually the bank, to consider whether or not they should reimburse the consumer for any funds lost as a result of APP scams. However, that's not to say there are no protections for consumers, and I'll take you through some of the measures and upcoming proposals the Payment Systems Regulator has in store for the sector. Just as a bit of background, the Payment Systems Regulator was established by the FCA following legislative reform led by the Treasury. It's established as a competition-focused utility-style regulator for retail payment systems and became fully operational in April 2015. So in 2019, the Payment Systems Regulator gave the UK's 6 largest banking groups a specific direction to implement confirmation of payee by the end of March 2020. With confirmation of payee, banks can check that the name on a new payee's account, as well as the sort code and account number. Customers setting up a new payee or changing details from an existing payee are able to confirm that the name they've entered matches the one on the account they intend to pay, helping to prevent payments going to the wrong account. However, and taking a bit more of a real-world perspective, if you are falling victim to a scam and you believe that the details you've been given are correct, maybe the fraudster has warned you that the account will be under a different name for security reasons, then this might not actually give you much protection in practical terms if you then go on to ignore the warning. So the next thing I want to talk about is the code. So the Payment Systems Regulator introduced the Contingent Reimbursement Model Code in May 2019, which aimed to reduce both the occurrence and impact of APP scams and is designed to give people confidence that if they fall victim to an APP scam and they've acted appropriately, they will be reimbursed. It sets out standards for signatory payment service providers, a group including the largest banks in the UK, and for customers who are covered by the code. So that's consumers, micro businesses, and small charities. The code established the general principle that where a customer has been victim of an APP scam, payment services firms should reimburse them. However, this is subject to a number of qualifications. Banks and other payment service providers may decline to reimburse customers where the customer ignored effective warnings when setting up a new payee or immediately before making the payment. So that's the confirmation of payee point that we mentioned earlier. The customer didn't take appropriate actions following a clear negative confirmation of payee result. In all the circumstances, the customer made payment without the reasonable belief that the payee was who they were expecting, or that the payment was for genuine goods or services, or that the person with whom they transacted was legitimate. And the last one here we've got is gross negligence on the part of the customer. There is one more exception in the code, but this relates to micro enterprises and charities not adhering to their own internal procedures for approving payments. So as a result of the code and the exceptions to reimbursement, there has been inconsistency in the way this principle that customers should be reimbursed for APP fraud has been applied to customers, and 2 banks may choose to treat a customer differently on the same set of facts. Prior to its introduction, there was no systematic protection for victims of APP fraud in the UK, and frankly, there were weak incentives for payment services providers to protect them, so it seems like it's a step in the right direction. However, this code is voluntary, and not all payment service providers in the UK have signed up to it. So even with the inconsistency in how the code itself is applied, depending on the provider and how they interpret the circumstances, there's also inconsistency as to whether it would be applied in the first place. And that very much depends on who the customer banks with and whether they have signed up to the code. So moving on to the consultation paper. So the payment systems regulator is currently consulting on new measures in relation to authorised push payment fraud. The consultation was launched in November last year and closed for responses in January. So there are three key proposals set out in the paper. The first one we've got here is publishing scam data. So the payment systems regulator will require the 12 largest payment services providers in the UK to publish a balanced scorecard of data setting out their performance in relation to APP scams. So this will include things like how much money is being reimbursed to customers and really kind of being able to compare that across the industry to different payment services providers. The second one is intelligence sharing. So the payment systems regulator wants to improve intelligence sharing between payment service providers to improve scam prevention. So this might be things like talking about key trends in the industry and whether one payment or like a collection of specific payment services providers are seeing a particular type of APP scam or a particular type of victim falling victim to APP scam. So just trying to improve the intelligence sharing and improve the knowledge within the industry. And then the third point, which is really the key one, is wider reimbursement. So the payment systems regulator wants all customers to benefit from reimbursement protections. This will require legislative change. So the consultation paper seeks views on how this could be achieved so that if and when the payment systems regulator is authorised to do so, it can act swiftly. We've yet to see the outcome of the consultation paper, but the payment systems regulator has been clear that it intends to act quickly when it has authority to do so. The reimbursement piece requires legislative change, but we're already seeing a move towards this, and Sylvia will touch on this later in the presentation. So where a customer falls victim to APP fraud and the bank refuses to reimburse them, what happens next? Typically, a customer will then make a complaint to the Financial Ombudsman Service. The Financial Ombudsman Service saw a 30% increase in authorised scam complaints in Q2 2021 versus the same period in 2020. The complaints made to the Financial Ombudsman Service are usually predicated on the fact that the consumer thinks their bank should have reimbursed them for the loss, or that the bank didn't do enough to help the individual when they fell victim to the scam. If you go onto the FOSS website, there are 431 complaint decisions which mention authorised push payment fraud. Of those, 189 were upheld. Usually these are where the Ombudsman takes the view that the customer did have a reasonable belief that they were making a genuine payment, or that warnings were either not present or too generic. The Ombudsman, in upholding the code, may also take account of the individual characteristics of the customer, such as age, when considering whether they would have a reasonable belief. However, the majority of complaints specifically in relation to APP fraud published on the FOSS website were not upheld. This is more likely to happen where the activity on the account isn't obviously suspicious. For example, the transaction values and frequency are in line with normal activity on the account, but this is clearly quite subjective. Where a customer has complained to the Financial Ombudsman Service and the complaint is not upheld, the customer could then choose to pursue the bank in litigation. And we've acted on both the customer side and the institution side in financial services litigation. So now I've taken you through what APP fraud is, the rise in APP fraud during the pandemic, and the protections that have historically been in place for victims. Sylvia is going to take you through some of the case law in this area, including the potential widening in scope of the Quincecare Duty.
Thanks, Lorna. So now Lorna has given us an overview of fraud, authorised push payments, and discussed the complaints process and redresses available. I'm going to look at when the complaints process can't resolve issues for customers when things turn litigious. So I'm going to discuss the Quincecare Duty, its development through the courts, and what it potentially means for banks and customers dealing with cases of fraud, particularly APP fraud. So our first encounter with Quincecare Duty originated from the English High Court decision, Barclays Bank against Quincecare Limited, reported in 1992. The facts of the case were: Barclays agreed a loan facility of £400,000 for Quincecare Limited to purchase 4 chemist shops. One of the conditions of the facility was that a deed of guarantee would be delivered up to the bank, guaranteed by Unichem Limited, who would guarantee Quincecare's liabilities under the loan facility. It was a term of the loan agreement that Quincecare's directors would invest £50,000 in the purchase. The agreement provided for the loan monies to be drawn down on 2 days' notice in writing. Quincecare was defrauded by its own chairman, a Mr. Harry Stiller, who instructed that £344,000 of the loan monies would be drawn down and transferred to PE & Co, a firm of solicitors. Barclays initially refused the request until a written instruction was received from Stiller later the same day. An assurance was also provided by another director of Quincecare that £50,000 had been invested in the purchase by Quincecare. With Stiller's instruction, the firm of solicitors transferred the money to the US and Stiller absconded with the misappropriated loan monies. Barclays then sought to claim repayment by Quincecare and enforce Unichem's guarantee. Quincecare and Unichem defended the action and counterclaimed that Barclays was in breach of a duty of care owed to Quincecare as their customer. A central question to be decided in the case was whether Barclays had been put on inquiry at the point they executed the transfer as to whether Mr. Stiller might be using the funds for an unauthorised purpose. The High Court concluded that it was an implied term of the contract between Barclays and Quincecare that the bank would use reasonable care and skill in executing Quincecare's orders. In performance of that duty, the bank was bound to refrain from executing an order if and for so long as they were put on inquiry in the sense that they had reasonable grounds for believing that the order was an attempt to misappropriate funds. The standard expected was that of an ordinary, prudent banker. The court pointed out that the principal relationship between a bank and its customer in respect of bank accounts is that of creditor and debtor, but when it comes to the drawing of cheques on an account or the execution of payment orders, the relationship is that of agent and principal. As agent, the bank owes fiduciary duties to its customer when executing orders on their behalf, and in doing so, a bank is bound to observe reasonable care and skill. Ultimately, Quincecare was unsuccessful in its counterclaim that the bank had breached its duty of care. The court opined that in the absence of considerations to the contrary, a banker was entitled to assume that a director of a corporate customer was not attempting to defraud the company. And so the Quincecare duty was established, a fiduciary duty that requires banks to exercise reasonable skill and care when executing a customer's instructions, a duty which means refraining from executing an order if put on inquiry that the instruction is an attempt to misappropriate funds. At the time, the Quincecare judgment was seen to strike the right balance between following a customer's instruction and protecting that customer against fraud, the customer in the case at hand being a corporate body. Now, fast forward to the present day, and fraudulent schemes are becoming more and more sophisticated, with fraudsters taking advantage of the increased use of technology in everyday banking transactions, as Lorna has alluded to. So turning now to the more recent case of Philip against Barclays Bank. And the facts of the case are, in 2018, Mrs. Phillip and her husband were victims of APP fraud after being convinced by a fraudster who made a series of telephone calls posing as representatives from both the Financial Conduct Authority and the National Crime Agency. Mr. and Mrs. Phillip were so convinced that they would be avoiding the risk of fraud by following the instructions of the fraudsters that they transferred a majority of their savings, £700,000, in 2 payments to accounts in the UAE. Mrs. Phillip then raised an action, claiming that the bank owed her a duty of care at common law, in tort or implied into the contract between her and the bank, or by statute under Section 13 of the Supply of Goods and Services Act. The duty, it was claimed, was characterised as a duty to observe reasonable care and skill in executing her instructions, a duty akin to that which was identified by the High Court in the Quincecare case. At first instance, Mrs. Phillip's claim was struck out, and the court concluded that the Quincecare duty did not apply, as it was limited to instances where instructions are not properly authorised, for example, where a customer's agent attempts to misappropriate funds, as were the circumstances of the Quincecare case. The court held that the Quincecare duty could not apply in circumstances where the customer themselves, rather than their agent, has made the payment instruction. The court considered that allowing an individual account holder to rely upon the Quincecare duty would constitute an expansion of its scope, which the judge was not prepared to allow. But it's worth noting that this is fairly typical of less senior courts, who will often defer to the superior courts to make potentially groundbreaking decisions. Absent the Quincecare Duty, the court considered that Mrs. Phillip would be unable to make out her claim, and so the case was struck out. The Court of Appeal, however, did not agree that the circumstances of Quincecare were so limited, reversing the High Court's decision to strike out and allowing the case to proceed to an evidential hearing. And we still have to wait for the evidential hearing to know whether the Quincecare Duty was a duty of care that was breached by the bank and its execution of the payments instructed by Mrs. Phillip. However, the judgment does tell us that the Quincecare Duty can, in principle, be extended to individual customers who have been the victim of APP fraud, provided that the bank is on inquiry that executing the order would result in the customer's funds being misappropriated. Although the Quincecare Duty has to date involved reference to a customer's agent, that was simply a consequence of the facts in those past cases. The Phillip case raises some interesting issues, which suggest the direction of travel for banks and their customers in cases of APP fraud. Mrs. Phillip contended there were not sufficient safeguarding questions or scam warnings given by the bank, a submission that is not accepted by the bank. Mrs. Phillip also contended that by March 2018, the bank ought to have in place policies and procedures for the purpose of detecting and preventing potential APP fraud and reversing or reclaiming money subject to it. The facts of these arguments are yet to be established in the trial, but it will be interesting to see how the court deals with these arguments. How far are banks expected to go in terms of warning customers or stepping in to prevent fraud? It was argued that there were various features of the payments and of Mrs. Phillip's own situation which would have alerted an ordinary prudent bank to the problem, with the result being that a bank acting with reasonable skill and care would have delayed these transfers and asked the questions to get to the bottom of what was going on. Such measures suggested were impactful warnings, carrying out further investigations, possibly even arranging for a meeting between the police and Mrs. Phillip. The appeal court discussed the judge's acceptance of the bank's submission that the duty, if applied, would be unworkable in practice and it would be commercially unrealistic to expect bank staff to ask the kind of questions which would be necessary to detect potential APP fraud whenever any payment instruction was authorised by the customer attending the bank in person. The Court of Appeal was critical of the lower court's decision that any recognition of the Quincecare Duty in a case such as the Phillip case would be onerous and unworkable. The appeal court saying that such considerations would be a matter for trial. The Court of Appeal found that there was evidence to suggest that the policies and procedures needed to protect against APP fraud would not have been onerous or unworkable under standard banking practices back in March 2018, that being when the APP fraud occurred. And part of the evidence referred to came from the Consumers Association, also known as WITCH, who were given leave to intervene in the appeal. Also referred to during the appeal was the then 2017 BSI Code of Practice, which sets out guidance and recommendations for banks relating to fraud and financial abuse, including APP fraud. This included staff training about understanding risk factors, recognising suspicious transactions, and recognising customers in vulnerable circumstances. The bank in its submission had presented the question, how can the duty possibly work in the context of the huge number of banking transactions executed every day, and particularly having regard to the speed of many of these transactions? Reference was made by example to the speed of transfer obligations on banks and the BACS and faster payment systems. Even if it would seem reasonable to impose a duty in a case like that of Mrs. Phillip, given the circumstances, if in law there is a duty of care, then it would apply across the board and thereby undermine the bank's ability to transact its customers' business in a timely fashion. But this was not accepted by the appeal court as a relevant consideration, the reasoning being that either duty of care was applicable or it was not. How a bank meets its obligations was not the question to be decided. So we don't have a final judgment for Quincecare just yet, but what does the most recent judgment mean for financial services providers? We now know that the Quincecare Duty can, in principle, be extended to non-corporate customers. It's not just applicable to agents acting on behalf of corporates or other bodies. And we are seeing an evolving expectation from regulators, not least with the incoming Consumer Duty, which requires those firms within scope to be placing customers at the heart of what they do and acting to deliver good outcomes for consumers. We're seeing a continual shift towards protecting consumers, and whilst our courts are distinct from financial regulators, while we see a bolstering of protection for consumers by the court in the context of Quincecare, it remains to be seen. So we await the final decision and whether the prospect that financial institutions will have increased responsibility for scrutinising and preventing payments authorised by their customers. So senior managers should be ensuring that the systems and controls they have in place are robust and designed to challenge payments being made where fraud is a potential concern. Financial institutions need to balance their mandate to process payments alongside the duty to make inquiries on whether an APP is genuine. So I intended to end this session by saying that we should keep an eye on this space, as APP fraud is a growing problem for the financial services sector. And in the spirit of keeping a watchful eye, it was announced yesterday in the Queen's speech that legislation would be introduced in an effort to help more victims of APP fraud to be reimbursed by banks and payment service providers. The legislative amendment would give the payment systems regulator the power to force firms to reimburse victims where it sees fit, a response to growing calls for greater protection for consumers where APP is concerned. We're yet to see the wording of the proposed legislation and how far it extends. But what is clear is that the government, regulators, potentially also the courts, are placing greater responsibility on financial institutions to safeguard their customers from fraud, even where there is a willful instruction from the customer, such as the case with APPs. And with that, I will bring to a close the final session of our Financial Services Regulatory Spring Series. Thank you so much for joining us. This and all the other sessions will be available to listen and view back. We would really encourage your feedback, any that you have, any comments, any queries, and we will be back later in the year with our autumn series. So do let us know if you have any suggestions for topics that you'd like us to cover, any feedback, any questions. Thanks so much for joining us and enjoy the rest of your day.
Thanks very much, everyone.